So today we begin our show with the
Phrase of the day?
Phrase of the day. And I said it sounded like ammunition, but you say it's a
Diminution.
diminution. And it's close to demolition and ammunition. But this is a word I've never seen.
And it really is, it's almost a combination of those two if you think about it. So,
Diminution in value.
diminution in value. So here's the scenario. You buy a brand new car. Pick a number for me. How much did that brand new car cost?
28,000.
$28,000. You drive it off the lot. So now it's a used car, right?
Yep.
And you are in a wreck within 100 feet of the dealership. You're rear-ended. It's not your fault. Back bumper smashed in. There's some damage to the frame. Well, the at-fault party, their insurance company's going to want to pay to fix your car. 6 weeks later, your car's perfectly fixed. But are you made whole? In other words, if the wreck hadn't happened, the value of your now used car would have been $28,000 minus whatever that is. And it's a lot.
Yep.
But now you've got a used car that's, quote, been in a wreck.
Yep.
And so you're really not made whole.
Yep.
And the difference between what that car would have been worth had it never been wrecked and what it's worth wrecked, that is a diminution, a decrease in your value, and is something that the person that caused this wreck ought to have to pay for. But I bring it up. I'm actually going to go to a seminar Wednesday specifically on it because these insurance adjusters, and if you can imagine, we deal with them all around the country. And they've got to try to figure out what the laws are in each of the different states. But to a person, they fight me every time saying, you can't get that in Kentucky. But they're wrong. And so trying to prove to them that, hold on, just because you fixed my client's car doesn't mean you've helped my client out. And Roth, a lot of folks, you have to take a loan out on your vehicle. So you got a $28,000 value car, you've got a $20,000 loan on it, it gets in a wreck, even though it's fixed. If you tried to sell it, you're looking at $15,000. So you're underwater on your loan, and while it's true the law doesn't care about your loan, this is the way we can help get you there by making a diminution in value claim.
In this world that we live in of information, Carfax is the company that
That's right.
Everybody. If you're looking to buy a used vehicle, you should ask for a Carfax to see if that vehicle's been in a accident, and you get to some extent more history of it than you want.
Yeah,
but
really.
Still, it is a good idea to do that if you're buying a used vehicle, and when somebody sees that, they diminish the value of it.
That's right.
As being a potential purchaser.
Absolutely, absolutely. So something to keep in mind. Anytime they've done something that's going to, even though they fixed it, it's still not as valuable as it would have been had it never been in the wreck.
Because when I was sitting there thinking, are there other scenarios? Well, when a house is damaged in, say, a hailstorm or whatever, it's put back good, and sometimes if it's a roof that's 8 years old,
Might even be better.
It might even be better.
Right.
But in the case of a vehicle, when you can see that this vehicle has been in a wreck, and sometimes it even describes the damage in these reports, you'll
chase off a potential buyer for sure.
Exactly.
The other scenario where you will see this phrase used is a road case, eminent domain. So let's say you've got 5 acres, you're kind of out in the country, it's beautiful land, and now the government's going to build a new highway.
Right.
They come through one of your 5 acres. They're going to argue, well, we only owe you the value of that 1 acre we took, so here's $5,000. But you're going to say, wait a minute, I had a 5-acre home in the country. Now I have a 4-acre home next to an interstate.
Right.
You have decreased the value of what you left me with, even if you pay for what you're taking. So diminution in value is a very similar concept that comes up there.
And that happens when we're relocating roads between here and Louisville.
Yeah, all the time.
31,
Exactly.
Where they go through somebody's property and actually have cut farmland in two. It definitely does that. Makes it harder to sell or harder to take care of.
Yeah, and just ultimately get your value out of it as it should have been.
Diminution in value.
There you go.
Keep that in mind, that you can do that. And like I say, very, very important, because the value of a vehicle can change dramatically in the eyes of a prospective buyer. It may not change if you plan to hang on to the car, but still, you should be compensated.
You should
for
be.
it.
That's right. That the law gives you that.
All right.
One of the things that we've talked about on the show before, and a lot actually, is the concept of negligence. And I always like to make sure people understand the difference between an intentional act and a negligent act. So if I come over and I hit you in the face because I'm mad at you, I've done that intentionally.
Mm-hmm.
If we're in here talking and I flip my pen and it hits you in the face, that was an accident. That could be negligence. And when we look at negligence, the law says there are 4 elements that we have to show in a negligence case.
You have a question for John?
They are duty, breach,
Okay, hold on.
cause, and injury. And so I thought what we could do today is take a look at that first element, the element of duty. When does a person have a duty to act, and what is that duty?
Okay.
So when we talk about a negligence case, and the reason this comes up, Roth, is a lot of people, I hear it, I'm a lawyer, but I hear people say, oh, I'm afraid to do X, Y, and Z because, those daggum lawyers will sue you.
Mm-hmm.
And I just want people to understand, don't worry about lawyers. They shouldn't be a concern in your mind. Yeah, you might get sued, but that doesn't mean that you did anything wrong or intentional or bad. But it might mean that you were negligent. And so the question then arises, well, how will I know if I'm being negligent? And so the answer is, well, if you've breached a duty that you owe to somebody, you will have been negligent. But that, of course, begs the question, well, what duties do I owe to you? And, we've talked before about landowners.
Mm-hmm.
What duties does a landowner own you when people are walking in and it's a snowy day, that
Right.
kind of thing. So I want to just look specifically at that first of the 4 elements, the duty. So where do we get this concept of what is my duty and who do I owe it to? And I teach a class, I have in the past, I'm not teaching it currently, at St. Catherine, and we spend a lot of time looking just at that concept. So the first thing to remember is the overall duty is to, quote, act as a reasonably prudent person. Okay?
Which we all hope we do, but
That's right. And so what does that mean, though? To be a reasonably prudent person. And you get lots of different subcategories of that. So the first one is, are we talking objective or subjective? So let me back up and explain
Okay.
that, because this is a big concept in the law, and I want to use the self-defense law to try to explain it. So in Kentucky, we have a subjective self-defense law, which means we want to know, what were you thinking at the time? So let's take a crazy scenario. I'm in my house and I truly believe, so just pretend that I believe this, that there are Martians attacking me. Now, if Martians were attacking you, if that really did happen, you would be freaked out and scared. I'm freaked out and scared. I think it's happening.
Thank you.
So I then act reasonably by shooting what I think is a Martian. Turns out it, wasn't a Martian, it was somebody selling Girl Scout cookies. So objectively, if we backed up and said, wait a minute, is that reasonable for somebody to think there's a Martian? Of course not. So that would never pass an objective standard. But a subjective standard, that person really truly believed it. They really thought they were being
In
reasonable.
danger.
Right. So for criminal law in Kentucky, we use a subjective standard, which is crazy, but it makes sense because you're not. We want people to feel free to act and protect themselves. In the negligence side of the world, though, it's an objective standard. We don't really ever ask, what were you thinking? We look at the situation and say, was that reasonable or not, objectively? And so that's kind of a big difference, but it's the first place that we have to start. The second thing is, when we want to focus on what is your duty to act or not act, is that not all of us are the same. You're taller than I am. Some people are shorter than me. You and I are blessed. We've got all 4 limbs. Some people don't. Do we take into consideration the person's physical condition? And the answer there is yes, we do. We want everybody to act reasonably, but a person who is a paraplegic and in a wheelchair, what's reasonable for them to do might be different than what's reasonable for you or I to do. So when we ask what is your duty, how do you act reasonably, we are going to give you credit for any physical characteristics that you might have. But now what about mental characteristics? Some people are smarter than others. Some people actually have a disability and are not even allowed to function. And the answer there, surprisingly, is no, we don't give you a break for any mental. So I see the puzzled look on your face. Why would that be?
Yeah.
And it has to do with if you're really not able to be out in society,
Shouldn't be.
you maybe shouldn't be. That's right. Because
and that almost falls back onto any guardians.
Exactly. So, so every situation that's going to come up when somebody's worried about did I do the right thing or not, you don't have to be perfect, but you do have to be reasonable, and we are going to take into consideration any physical limits, but we're not going to give you any break on any mental handicaps that you might have. So then comes the question of action versus inaction. What if, I walk by and I see a little boy has fallen into an icy pond and I don't stop to help? Am I being negligent or not? I didn't do anything, so I didn't take any action. I failed to act. And in that situation, we're going to look and see what your relationship is with the person. So as a general rule, though, there is no liability for non-action, which, you can argue that till the cows come home, I guess. But I think this society is very much say you're at Walmart and you see what you think is a mother treating a child poorly. Do you have to jump in there or not? Should you jump in there or not? And everybody's going to disagree or differ on that. But the law says unless you caused a situation, so for example, if I took the little boy's puppy dog and slid it out on the ice,
Right.
then it might be, now I've got a duty to act if the child goes out there after it, that kind of thing.
Chad, the current events on something similar to that, Kentucky is now moving forward with this drug that's able to stop people that are having a seizures or whatever, a drug overdose.
Right.
Yeah. And I believe, did the Kentucky legislature go all the way through with the thing of somehow enacting a law that said you would not be liable if you administered this to a person?
I haven't seen if it passed yet. But
I knew it was in the hopper there.
Yeah, and we've always had that Good Samaritan law.
Yeah.
If you stop to act,
Okay.
can you get in trouble if you screw it up?
Yeah.
And I think, and don't hold me to this, I'd have to look it up, but I think the way Kentucky has come out, no, unless you're an EMT.
Yeah.
So if you're somebody with special training and you stop to help and you mess up your special training, then yeah, maybe you are. And one way to think about that, you go back to that reasonably prudent person, and I probably should have touched on this. If you are somebody with some special training, we are going to hold you to that. So it would go from a reasonably prudent person to a reasonably prudent fill in the blank. So for example, when a doctor is operating on you, we don't expect them to act like a reasonably prudent person. We expect them to act like a reasonably prudent doctor. Now, I don't know what a reasonable doctor would do in a situation. That's why I have to go get expert witnesses to come in and tell me. If it's an EMT doing the Good Samaritan, what should they have done? That kind of thing. So when you get into these specialties, engineering is another one, law is another one, we have to bring in experts on it. So it doesn't really change the standard, act reasonably, but when we have to answer the question of, well, what is reasonable, now we've got to go bring somebody else in. So one other thing to talk about, and I see we're getting near the end of our time, another place that a duty can come up is a safety statute. We have some laws in Kentucky that are designed to protect people. And if I can show that you are a person who was in that class of people that should have been protected, and that the other person failed to follow the law, then the failure to follow that law can actually give rise to the duty. And when it does, we call it negligence per se. So here would be an example. There is a work safety law that says if you have an employee on a platform higher than 4 feet, I think it's 4, maybe 6, higher than whatever number, then they must have fall protection.
Safety harness.
Safety harness. Okay, so let's say you've got an employee, they're up walking on the cat tracks, they fall and get hurt. If I can show then that you, the employer, didn't follow the safety statute, the person who got hurt was somebody who was designed to be protected by the statute, then it's negligence per se. And so remember those 4 elements: duty, breach, cause, and injury. Negligence per se means I've already shown duty and breach. We're now just talking about damages. So it's kind of a victory for you. But stick with that same example. What if an employee is walking on a cat track and the employee falls off the cat track and crushes somebody who was there visiting the plant? Well, the person who's going to bring the suit that was visiting the plant, they won't get to argue negligence per se, because that statute was not designed to protect visitors. It was designed to protect the worker. See that little weird distinction there? So you're not one of the people that the law was there to protect. And doesn't mean there's not going to be negligence. It's just not negligence per se.
Okay.
So you get to kind of go there. So it's interesting. And Kentucky is a pretty unique state in this respect. We also have a law that says if you've been hurt because somebody else violated a statute, you can take action and sue them. It's called a private right of action. And most states don't have that. But I think it's great. I mean, it gives us a kind of a what to expect out there,
I wrote myself a note about seat belts. It is the law. We must wear seat belts. Right. Whose responsibility is it? Is it the driver of the car to make sure everybody is seat belted?
I think it is the driver of the car to make sure. And this is where you're going to get into criminal and civil liability, and then you're going to get into adults. You're an adult. I can't make you wear the seat belt, if you're in my car. Now, maybe I could say you're not going to ride with me. By the same token, though, an adult then is making an assumption of the risk and doing it on their own. So take the seatbelt law for a minute and take a crazy hypothetical. My car crashes, you're in the front seat, you don't have your seatbelt on, you get ejected, and you land on a little old lady and break her hip. Is she going to be able to argue negligence per se because you broke a safety law? No, because she's not one of the people that was designed to be protected by that law. It's there to protect you, not her. So it's kind of a weird analysis, but something for us lawyers, we're always looking for negligence per se. It's kind of gets you real close to the victory line there.
Well, I know that when I'm the driver of the vehicle, if somebody gets in and doesn't buckle in, we don't move.
I'm same way. That's kind of my rule as well.
It's like I'm seeing too many fines. Number one on the in the court system,
and number two, my car has this annoying beep that
and then you just hear of accidents and they're on the interstates and people are ejected from vehicles in an accident and they weren't wearing a seatbelt.
I can't tell you though how many times somebody will come to me and say, "Yeah, but I was told if I had been wearing my seatbelt, I would have been killed." And I'm like, "No, that's ridiculous. Wear that thing."
Yeah. So be safe.
Be safe. That's right.
Well, we've got. Don't worry about time. Is there something else we need to cover on that?
Well, no. I mean, I actually brought my whole outline. So no, it's a whole semester's worth of.
Class is dismissed.
Class is dismissed. That's right.
It is interesting about the fact of negligence, because as you were saying earlier, I was going, okay, the difference between intentionally doing something and just doing something because of maybe negligence, or it could be the difference between a criminal thing and a civil thing.
Yeah, absolutely.
You do something on purpose. If you elbowed me on purpose, that's criminal.
It could, but it's also civil. We do have civil torts, intentional torts. Assault, battery, false imprisonment. These are all intentional things that happen. The reality is, though, lawyers don't really bring those cases because there's never any money to collect for the victim. Because if it's intentional, insurance will say, "Sorry, we're only here for negligence."
Yeah. All right. Well, let's again remind everybody how they find your law firm.
Absolutely. We're on the web, McCoy and Heaston. You can also call us at 1-800-254-4444 or 502-233-8385. We've got an office in Louisville over near the St. Matthews Mall at 104 Browns Lane, and here in Bardstown just down the street from the radio station at 114 South 3rd. I think we're on Facebook, Twitter, all that stuff, so we ought to be easy to get a hold of if you need to find us. And feel free always, just to, if you've got something you're just curious about, give me a call. Glad to talk to you.